Okay, so 700. Eligible offender means a person who has been convicted of a crime, but not more than one felony. 701. This is true. It's not construed as to apply to the right of the person to retain or be eligible for public office. Okay, a certificate of relief from civil disabilities shall not be issued by a court unless court is satisfied 1, person is eligible, 2, consistent with rehabilitation, and 3, consistent with the public interest. So this is why 3 is wrong, because it said interest of justice. Both certificates, whether it's the good conduct, both certificates, whether it's the certificate of good conduct or the relief from civil disabilities, it's based on consistent with the public interest. So it's rehabilitation, public interest, and eligible. And then for the certificate of good conduct, the one you could get with multiple felonies, that one, it's conducts herself in a manner warranting the issuance for the minimum period, consistent with rehabilitation, and consistent with public interest. 703. In granting or revoking a certificate, the action of the department authorized to grant or revoke parole, the Department of Corrections and Community Supervision, shall be deemed a judicial function and shall not be reviewable if done according to law. 703-B. The Department of Corrections and Community Supervision shall have the power to issue a certificate of good conduct to any person previously convicted of a crime in this state when department is satisfied, 1, that the applicant has conducted himself in a manner warranting such issuance for the minimum period, 2, consistent with rehabilitation of applicant, 3, consistent with public interest. The periods are, for a misdemeanor, it's 1 year. D, C, E felony. C, D, E felony, 3 years. Class A or B felony, it is 5 years. That's my dog we're looking at there. He wears pajamas. 700 sub 2. This is true. 2 or more convictions of felonies charged in separate counts of 1 indictment or information shall be deemed to be 1 conviction. Now, I don't know why that's true, because it says felonies, and felonies aren't in an information, but maybe they meant superior court information. Let me see. This is number 7. Yeah, I think that's what they meant. It's pure like SCI. 703. Which, if any, of the following are true? 1. The Department of Corrections and Community Supervision may issue a certificate of relief at time offender is released from an institution under the jurisdiction of the department or any time thereafter. 2. Department, in determining whether the certificate shall be issued, shall conduct an investigation of the applicant. 3. Any certificate who at the time is under supervision shall be deemed temporary until the person is discharged from department supervision. 704. A person who knowingly uses or attempts to use a revoked certificate shall be guilty of a misdemeanor. Sex offense includes a conviction of or a conviction for an attempt to commit any of the provisions of 130.52 or 130.55, provided that the victim is less than 18, so 0 to 17. 130.52 is forcible touching. I don't know what the other one is. 160-A, sex offense. I already did that. This is 160-B. Division charges $10 to change the address, but if they don't pay the $10, they still have to process it. This says, in the case of any sex offender, it shall be duty of department, hospital, or local correctional facility at least 10 days prior to the release or discharge of any sex offender from a facility, hospital, or local correctional facility to notify the division. So, like, if I'm going to go rape, Jason Momoa when he's dressed up as, like, the Dothraki, and I go to, like, prison, and I'm registered as a sex offender, I have to, then before I get out, 10 calendar days before I'm going to get out, I got to go register. And, the hospital or jail or wherever I got out of has to notify the division within 10 calendar days. 168-D. In general, which of the following are true concerning the duties of the court upon conviction of any of the offenses set forth in subdivision 2 or 3 of 168-A and Article 6-C of the correction law? 1, court shall certify person is a sex offender. 2, court shall include the certification in the order of commitment, if any, and in the judgment of conviction. 3, court shall advise sex offender of his or her duties under this article. And it's all 3 of them. 14, if a hearing needs to be held, the people's burden of proof is clear and convincing. And so held without a jury. 168-D, any sex offender who is released on probation or discharge upon payment of a fine, CD or UD, shall, prior to the release or discharge, be informed. So that means in court. That's basically what it means, because they're not in jail or anything. Be informed of her duty to register on this article by the court in which she was convicted. At the time sentence is imposed, the person shall register with the division on a form prepared by division. Court shall require the offender to read and sign such form and complete the registration portion. The court has to make 3 additional copies, 1 for the sex offender and 2 for the division that they're going to forward. Court shall also notify the DA and sex offender of date of determination proceeding to be held, which shall be at least 45 days after notice is given. Again, this is for probation, conditional discharge, fine, etc. The court shall notify the DA and sex offender of date of the determination proceeding to be held, which shall be at least 45 days after such notice is given. 45 days. How the fuck am I going to remember that this one is 45 days? Anyway, 17. Okay. Any sex offender shall at least 10 calendar days before parole, release, etc. register with the division on a form prepared by the division. So they have to, so like if I'm in jail, you know, for like being a sex offender and I'm going to get out, I got to register 10 days prior to discharge, and the jail has to notify the division 10 days before my discharge. 168-J, upon receipt of a change of address. Okay, first I'm going to say this. If the sex offender is on probation, parole, etc., the probation or parole officer must notify the division within 48 hours. And then upon receipt of the change, but no event more than 2 business days after such receipt, the division shall notify the local law enforcement agency having jurisdiction of the new place of residence and the local law enforcement agency where the sex offender last resided of the new place of residence. 168-N. A determination by the court regarding sex offender level shall be made prior to discharge, applying guidelines after receiving a recommendation by board. No later than 30 days prior to the board's recommendation, the sex offender shall be notified that her case is under review. This is that crazy rule where it goes where, like, it's 120 days, 60 days, 120 days for like the jail to make send information to division. Then the division has to do something 60 days before like the person is going to get released, and then they have to notify the sex offender 30 days before they make the determination, so the sex offender has time to like submit whatever they want to prove that, you know, that they should like consider these mitigating circumstances or whatever. Okay, so for level 2 and 3, it's a lifetime and they're ineligible for public housing. Risk of repeat offense for level 3 is high, level 2 moderate, level 1 is low, and there's a subdirectory for the 2 and the 3. If a sex offender fails to appear at a hearing, the hearing has to be held anyway, they don't have a good reason. Duty to appear for photograph. It's within 20 days of the first anniversary. Local law enforcement agency sends notice at least 30, but not more than 60 days, telling the sex offender about like what day they have to come in for the photo. And that's it for this. I mean, like my video is like 2 hours long, but hopefully if they're going to ask a question on corrections law, it'll be one of these.